Welcome to State Law Exposed, where real people, real laws, and real money collide. Every story you're about to hear happened right here in Florida under real statutes, in real courtrooms, with real consequences. These are the laws that hospitals, surgery centers, and insurance adjusters are praying you never Google. If you've ever felt outgunned by a system that wasn't built with grieving families in mind, you're exactly where you need to be. Hit subscribe right now, because the next story might be yours. This is State Law Exposed. Her husband was 54, healthy, strong, a father of two. He went in for a procedure at an Orlando surgery center, a routine one. He never came home. Linda spent 6 months just trying to survive the grief, thinking about her children, not lawsuits. But in Florida, the clock does not stop for grief. Florida's wrongful death law gives you 2 years. 2 years sounds like enough. It is not. Because before you can file a single court document in a Florida medical malpractice case, the law requires you to complete a mandatory pre-suit investigation process, and the time it takes to prepare for that process eats directly into your 2-year window. Linda's attorney began that process 7 months after James died. She nearly ran out of time. Tonight, exactly how that nearly happened, and how Linda's family recovered $1.4 million by understanding the rule that almost cost them everything. James was not a complicated medical case going into that surgery center. He was healthy. He was 54. He had 2 teenage children and a wife in Orlando who expected him home for dinner. What the procedure was is less important than what happened after it, because what happened after it is a story about monitoring and about what happens when monitoring fails. In the recovery bay following his procedure, James's oxygen levels dropped. They dropped slowly, and nobody caught it. No alarm triggered in time. No nurse intervened in time. What a board-certified anesthesiologist would later describe as inadequate post-procedural oxygen monitoring, a gap in continuous pulse oximetry during the recovery period, allowed James's oxygen levels to fall without detection. By the time he was found unresponsive, the damage was done. He was transferred to the hospital by ambulance. He did not recover. He died the same day. Linda spent 6 months doing what people do when someone they love dies suddenly, managing the estate, holding herself together for the children, receiving condolences, trying to understand what her life looked like now. She was not thinking about lawsuits. She was not thinking about statutes. She was thinking about survival. At month 7, a family friend who was also a physician asked if he could review James's medical records. Linda handed them over. The physician called her a few days later with something specific. There were gaps in the post-procedural monitoring documentation that he found troubling. The intervals between recorded pulse oximetry readings were inconsistent with continuous monitoring. He told Linda she should speak to an attorney. She made the call. What happened next is where Florida law gets complicated, and where the clock Linda had been ignoring suddenly became everything. Most people assume that when a loved one dies due to medical negligence, you hire a lawyer and file a lawsuit. In Florida, you cannot do that. Not yet. Before a single court document can be filed in a Florida medical malpractice case, the law mandates an entire pre-suit investigation process under Florida Statute SS 766.106. Here's what that process requires in order. First, the attorney must complete an investigation and obtain a verified written opinion from a qualified medical expert, a physician in the same specialty as the defendant, confirming that there are reasonable grounds for a negligence claim under SS 766.2032. Second, only after obtaining that expert opinion can the attorney serve a notice of intent to initiate litigation on each prospective defendant. Third, once that notice is served, the statute of limitations is paused for 90 days while the defendant conducts their own investigation. Only after those 90 days can a lawsuit actually be filed. Here is the part the source document got wrong, and it matters enormously. The source said the 90-day pre-suit period runs inside the statute without pausing it. That is incorrect. Florida Statute 766.106 explicitly states that the statute of limitations is tolled, legally paused, from the moment the notice of intent is mailed through the entire 90-day investigation period. The 90 days is not eating your time. But here is where the real danger lives. Everything that happens before you can serve that notice is not told. Finding the expert, reviewing potentially thousands of pages of medical records, having the expert form and verify their opinion, negotiating their availability, preparing the notice package under SS 766.2032 requirements. All of that takes months, and every single day of that preparation time runs against your 2-year clock with no pause, no extension, no mercy. In Linda's case, that preparation window was what almost swallowed the statute. James died on March 28, 2023, and Florida's 2-year deadline for wrongful death medical malpractice claims ran to March 28, 2025. Linda hired her attorney in October 2023, around month 7, and that gave time to request records, find the right expert, review thousands of pages, and secure a board-certified anesthesiologist for a written opinion. By the time the notice of intent went out and the 90-day tolling period began, it was already early 2024. If she had waited just 2 more months, the case timeline may have slipped past the point where there was enough time to prepare properly. Every week, she waited helped the defense. The board-certified anesthesiologist retained by Linda's attorney reviewed the surgery center's post-procedure monitoring logs carefully. What he found was documented in his verified written opinion. The intervals between recorded pulse oximetry readings during James's recovery period were inconsistent with continuous monitoring. Standard of care for post-procedural recovery requires continuous pulse oximetry, automated, alarmed, and documented at regular intervals. James's records showed gaps, not subtle ones, gaps that indicated monitoring was either intermittent, interrupted, or inadequately supervised during the window when his oxygen levels declined. The expert's conclusion, inadequate post-procedural oxygen monitoring was the proximate cause of James's death, the failure to detect the declining oxygen levels in time to intervene. That verified written opinion became the foundation of the notice of intent served on the surgery center. Once the notice of intent was served with the expert opinion attached, the 90-day clock for the surgery center's investigation began, and simultaneously the statute of limitations was told. The surgery center's insurer assigned a medical review team. Their investigation produced a response denying negligence. Their own internal review characterized the monitoring as adequate and attributed James's decline to underlying factors unrelated to the recovery care. Linda's attorney had expected this. The pre-suit denial is not the end of anything. It is the procedural clearance that allows the lawsuit to be filed. The surgery center's denial confirmed that the case would proceed to litigation. The complaint was filed within the required timeframe following the pre-suit period. Discovery began. The surgery center's own protocol manual was subpoenaed. What it showed, the required monitoring frequency versus what the records documented, became the center of the case. During discovery, Linda's attorney obtained the surgery center's own post-procedure monitoring protocols, which required continuous pulse oximetry and readings at specific intervals. But James's recovery log showed gaps longer than the facility standards allowed, long enough, in the expert's opinion, for his oxygen level to fall without triggering an alarm or intervention. The center's own written protocol became the most damaging evidence in the case. Linda didn't have to prove the standard of care from scratch, because the surgery center had already defined it itself. The only question was whether they followed their own rules. The record showed they did not. Florida's Wrongful Death Act, SES 768.21, allowed Linda to recover for James's future support and services, loss of companionship and protection, and her own mental pain and suffering from the date of his injury. Their 2 teenage children also qualify for damages for lost parental companionship, guidance, and mental pain and suffering because they were under 25 and there was a surviving spouse. The estate could recover James's lost earnings from injury to death, plus his projected future net accumulations, reduced to present value. A key limitation applies only to adult children over 25 in medical malpractice cases, so it did not affect Linda's teenage children. The case proceeded to mediation before trial. Both sides came in with documented positions. Linda's attorney had the monitoring gap, the expert opinion, the surgery center's own protocols, and the damages package. The surgery center's insurer had the pre-suit denial and a defense that aging and underlying health factors contributed to James's decline. In the mediation room, the monitoring log was everything. The gap between what the surgery center's own protocols required and what the records showed was not a subjective matter of expert opinion. It was arithmetic, specific times, specific readings, specific gaps. The insurer's risk calculation, when the protocol manual was placed beside the monitoring log, shifted significantly. The case settled for $1.4 million, covering Linda's loss of support and companionship, the children's loss of parental guidance, and the estate's projected future income loss. The surgery centers paid. No trial was needed. Florida's S768.21 has a rule every family should know. In medical malpractice wrongful death cases, adult children aged 25 or older generally cannot recover loss of companionship or mental pain and suffering damages. That is why critics call it Florida's free kill provision. If a parent dies from medical negligence and the only surviving children are adults over 25 with no surviving spouse, some non-economic damages are not available. The Florida legislature passed a bill in 2025 to change that. But Governor DeSantis vetoed it, so the restriction still remains in effect as of 2026. The lesson from Linda's case is precise and urgent. If someone you love dies in Florida following a medical procedure, and you suspect negligence, the clock started the day they died, not the day you found out what happened, not the day you finished grieving, the day they died. From that date, you have 2 years. But that 2-year window starts shrinking the moment the death occurs, because the preparation required before you can even serve the mandatory pre-suit notice takes months. Every week you wait before calling a Florida medical malpractice attorney is a week of preparation time you will never get back. And unlike other legal areas where delay is merely inconvenient, in Florida medical malpractice, the consequence of missing the deadline by a single day is the permanent, irreversible loss of all legal rights. The case does not slow down. The insurance company's investigation starts the day James died. Yours should too. One action. If you have lost a family member after a medical procedure in Florida and it has been less than 2 years since their death, call a Florida medical malpractice attorney today. Not next week. Not when things settle down. Today, most offer free consultations. The call costs nothing. The preparation of the pre-suit investigation takes time you may not have. If it has been more than 18 months since the death, call today and tell the attorney that immediately. They need to know how much preparation time remains. If you are not sure whether what happened was negligence, call anyway. The attorney's investigation will answer that question. That is what the pre-suit process is designed for. The law was already on Linda's side the whole time. What she almost ran out of was not rights. It was time. Don't repeat that. Make the call. One family, one procedure, one deadline that almost cost them $1.4 million. Not because they weren't paying attention, not because they didn't care. Because Florida's mandatory pre-suit process takes months to prepare, and that preparation runs against your 2-year clock from day one. That knowledge is power, and power should never be kept secret. If this episode changed how you see your rights after a medical procedure, hit like right now. Share it with every Florida family that has lost someone. You never know whose case you might be saving. And if you're not subscribed, what are you waiting for? New episodes every week, real law, real stakes, real people. Until next time, stay informed, stay protected, and never let them tell you the law isn't on your side. This has been State Law Exposed.